Hello, my name is Aaron Snoswell. I'm a computer scientist and I'm presenting today on behalf of myself and my co-authors Dr. Henry Fraser and Rhyle Simcock. Henry is a tech lawyer and a legal academic, and Rhyle is a PhD student looking at judicial review of automated government decisions. Our paper is about explainable AI in lawsuits, specifically civil litigation. So, it had to happen eventually. Last year, police officers in Texas sued Tesla in a negligence and product liability lawsuit after being injured by a Tesla on autopilot during a traffic stop. This won't be the last AI lawsuit. Tort law involving lawsuits for civil wrongs is one piece of the accountability puzzle for artificial intelligence. As with other forms of AI accountability, AI opacity of various kinds will pose a challenge in lawsuits. Our paper explores and evaluates strategies for dealing with that challenge with a focus on English, Australian, and US law. We start off with a list of different kinds of AI opacity compiled in the excellent work by Jenna Burrell and also by Seltz and Barocas, shown here on the slide. In a moment, we'll get into more detail about what each type of opacity means by seeing how they all appear in this recent Australian court case that we look at, ACCC and trivago. But more importantly, we'll explain how the court managed to deal with opacity quite successfully in this particular lawsuit. And then we'll work outwards to explore other strategies for dealing with opacity in other types of lawsuits, especially negligence lawsuits. But first, one of the main things we want to get across is that the kind of explanation required in lawsuits is distinctive. As Watcher, Middlestat, and Russell point out, the scope and content of explanations should be driven by the goal or action they are intended to support. And now, in litigation, the goal isn't necessarily a general explanation of an AI system's function or its decision-making. The goal is to provide evidence to the court that something about the system or its development was unlawful. So explanations need to prioritize the cause of action in the suit, a set of facts that have to be proven in order to succeed in a lawsuit. The trivago case, which we look at in our paper, illustrates this clearly. In this case, the ACCC, Australia's consumer affairs regulator, claimed that trivago misled consumers into believing that its travel website would help them find the cheapest available rates for hotel rooms. The central issue here was trivago's top position offer, an algorithmically generated promotional deal presented to consumers as the cheapest available offer for accommodation. It was critical to know whether the top position offer was determined by price or by commissions paid to trivago by online booking providers. So, both parties needed to explain how trivago's ranking algorithm generated the top position offer. There are some key lessons that we take away from this case. First of all, the algorithm was confidential and commercially sensitive. But the case shows how courts can deal with this problem of intentional secrecy, this type of AI opacity, by setting up discovery or disclosure and inspection regimes that mandate access to the algorithm and to its documentation, whilst also protecting confidentiality. A second challenge is to make sure that the judge and the litigants could actually understand the technical aspects of trivago's top position algorithm enough to enable meaningful determination of the issues. Trivago was a masterclass in using expert witnesses to explain technical subject matter. The real coup d'etat was to get the experts from both sides to write a joint report setting out the points of agreement and of disagreement, which made it very clear where the parties differed and where they agreed. A third challenge is that explainable AI methods can't produce complete or perfectly reliable explanations of AI systems, at least not in the case of post hoc explanations of black box systems. This speaks to the inherent inscrutability of complex AI systems. In the trivago case, there was disagreement between the experts about how reliable each other's methods and explanations were. But courts are used to reconstructing facts from incomplete, conflicting accounts. This is, in fact, exactly what courts do. Parsimony is key here. Courts only make determinations about what they need to determine. The judge in trivago didn't need a comprehensive, flawless explanation of everything about the trivago algorithm. It was enough that, in spite of disagreements, both sides' experts testified that the top position offer was often not the cheapest offer, and that commissions paid were highly important in the selection of this top position. That's what was critical for a suit about misleading claims and about easily finding the cheapest offer. One final takeaway from this particular case is that the choice of explainable AI methodology, and therefore the type of evidence provided to courts, will be shaped by the level of access to the algorithm and its underlying documentation and supporting systems. Each side's experts approached the method of explaining the weights of the algorithm's features in different ways because they had different levels of access to the underlying AI system. The ACCC expert used gradient boosting to reverse engineer the top position algorithm because he hadn't received the actual weights used in the trivago algorithm. At that point in time, they only had access to the logged data obtained in discovery. The trivago expert, by contrast, had full access to the system and therefore didn't need to rely on reconstructing a surrogate model. On that note, the ACCC's success in trivago shows that it is possible to provide explanations of AI systems that are effective in litigation with less than total access to a system. So one of our paper's key contributions is to categorize and describe different kinds and degrees of access that we might see feasibly in court cases, and what kind of explanations these types of access might permit. So we propose 3 different levels of access to an AI system model, shown here in the figure. Debugging access is like an all-access pass, for example, letting the plaintiff or their expert witness step through model execution, interrogating intermediate outputs and gradients, etc., just like the developer of the AI system would during development. This could, for example, take the form of a restricted VPN access to a development environment, or a Docker image or some other image with all the system's libraries and dependencies installed. Descriptive access, on the other hand, would be if you only had documentation about the system, or perhaps you had the details or even the code for a model's architecture but no weights or checkpoint files. In this case, you could only make general inferences about how the model might behave because you don't have the specific model instance that was used in this application. Query access, meanwhile, is a middle ground where a plaintiff can submit input data and observe the generated system outputs, for example, through an API. Armed with this taxonomy of different levels of access, let's look at a few different strategies for dealing with AI opacity in tort litigation. In the paper, we look at 2 bread and butter torts, product liability and negligence, but given time constraints, we'll focus here on just negligence. One way to sidestep AI opacity altogether is to frame the legal claim around something that doesn't require access to the AI system. For example, in the Tesla lawsuit, some of the claims focus on failure to warn of or remediate a known risk, because the accident is one of a series of more than a dozen in similar circumstances. This kind of suit, failure to warn or failure to remediate, is likely to become a quite common opacity hack, if you like. In other cases, plaintiffs may be able to persuade judges to draw broad inferences from limited information to overcome opacity, or even treat opacity itself as indicative of fault. Trivago is a good study in a different strategy. Using XAI but keeping the inquiry narrow, the ACCC chose to focus their case on misleading claims rather than on some inherent fault in the Trivago algorithm, because it distills their inquiry into a true or false question: does the algorithm work as advertised? The problem with these inferential approaches is that they require the court to make rather large leaps of reasoning, and for some kinds of wrongs or harms, the narrow Trivago approach won't be feasible. That's the case for negligence, for example, which is the quintessential flexible fallback tort lawsuit for accidents. Let's imagine a self-driving car plows into a stationary police car with its lights flashing on a highway at night, and someone is injured. How might the injured person, the plaintiff, put together a negligence claim against the developer of the car's object detection system, the defendant? A negligence claim involves a multi-stage inquiry where you work out several things: whether there's a duty to take care, whether that duty was breached through failure to take reasonable precautions, and whether that failure is what actually caused the accident. The slide here shows these 3 limbs of the negligence cause of action as key subcomponents. The role for explainable AI in accidents involving AI systems is to prove that causal connection between the failure of precaution, the breach of duty, and the accident. Doing what the experts in Trivago did, explaining the model feature importance, doesn't tell you whether an accident could have been avoided with an exercise of due care, so you need a different approach to explanation in this case. To satisfy the causation test in negligence, the plaintiff has to show that, on the balance of probabilities, the accident would not have happened but for the defendant's failure to take due care. The but for part of the test invites counterfactual thinking. Would the accident have happened if the developer had done A instead of B? Furthermore, the balance of probability standard of proof opens the door to empirical statistical kinds of reasoning. It means you have to show that some failure of a precaution was more likely than not to have caused the accident. If you take that standard seriously, as Stapleton famously pointed out, you're trying to establish that the failure precaution more than doubled the risk of the accident. This is a very precise empirical claim that can be tested with data. So, in our paper, we propose one particular approach to satisfying these tests, which is summarized in this flowchart here. There are differences to the causation test from jurisdiction to jurisdiction, but showing that some cost-effective precaution would have more than halved the frequency of the error that led to the accident, and that the developer didn't take that precaution would be very compelling to a court. And in principle, it would be possible to do this using a range of explainable AI methods, which we consider in more detail in the paper. The takeaway is, if you can work out empirically that an AI system has a certain error rate given inputs similar to those at the time of the accident, which is steps 1 and 2 on the slide, say a certain rate of object detection failure in nighttime driving conditions on a highway with a stopped vehicle and flashing lights. So in fact, the American Automobile Association recently did something very similar, testing driver assist systems responses to head-on collision scenarios. And you can show counterfactually that some reasonably cost-effective change or precaution in development would have more than halved that error rate, which is step 3. So if you put these two pieces together, then you're showing that it is more likely than not, that the accident-causing error is attributable to the failure of precaution, because more than half the errors of that kind are attributable to the failure. In other words, you're showing on the balance of probabilities that the accident would not have happened but for the failure of the precaution. So to be clear, we aren't suggesting that all negligence or product liability claims will or should boil down to this kind of a formula or strategy, or that it will be a cost-effective mechanism for accountability. What we are trying to illustrate in this paper is that with some creative legal and technical thinking, explainable AI methods might be able to be applied to the distinctive and specialized task of providing explanations which are salient for lawsuits. Naturally, our approaches and theories have limitations and challenges. Broadly speaking, the more complex the use of explainable AI, the more difficult and expensive it would be to pull off in a court setting. This is true of the counterfactual approach, especially if you're dealing with systems embodied in the physical world, such as a self-driving vehicle. More straightforward ways of dealing with AI opacity will be cheaper, but they have the disadvantage of relying more heavily on broad inferences. There's also the old saw about AI unpredictability and the impossibility of foreseeing and preventing all harms. Even if you can show that some precaution was feasible and that you would have substantially reduced one risk, you'll end up in a fight about whether mandating that precaution would have been tantamount to mandating comparable precautions for a vast array of other similar serious but equally unpredictable risks. Which measures are reasonable and necessary and which ones aren't is an open question. But in some sense, this question is exactly what we want courts to answer, even if only to prompt corrective standard setting by regulators and legislators. And courts can only develop the law to set the standard of care for AI if there are cases before them. What we're offering here are suggestions essentially about how to make that happen in the face of AI opacity, making the most of the tools we have at our disposal right now. We'll leave you with a list of priorities to give civil lawsuits the best chance of working as an accountability mechanism for AI. Thank you.